Mercedes Colwood, a Fox News legal analyst, and Kirsten Wilson, who is a former prosecutor. Good to see you both.
Good to see you.
All right, Kirsten, obviously the defense is trying to show duct tape and suffocation was not the cause of death because it wasn't wrapped completely around the head. But this was a body that was badly decomposed. It was in the open, in the woods, wild animals pulling it apart over 6 months. I mean, I would not expect duct tape after that period of time under those conditions to be fully wrapped around the head.
That's exactly right, Greg. There's a lot of things coming into play. We're talking about southern Florida, decomposition, wild animal activity. The fact that the duct tape was there and the vivid video that was played to the jury the other day that showed sort of the width of the tape and how it could cover both her nose and her mouth is powerful, powerful evidence.
A few minutes ago, we played Mercedes in the opening statement of the defense attorney, sort of blaming this meter reader, Roy Kronk, who discovered Kaylee's body, claiming that, and it's a pretty outrageous claim, that he tampered with the evidence, had the body for a while. Kronk denies it, and there really is very little evidence of that. But, is that the kind of thing that could render some of the evidence, including the duct tape, irrelevant?
And that's exactly right. I mean, obviously, the fact that it's not wrapped around, and when with your exchange with Judge Freer, you talked about it. You said, look, the prosecution put it there right center and say suffocation was the cause of death. And now you've got the reasonable doubt. Well, wait a minute, the tape's not wrapped around her skull. Maybe suffocation wasn't the means of death. And now this meter reader. Obviously, the defense is saying, look, he was the one who tampered with the body. Well, and that would make sense. If you don't have the duct tape wrapped around her skull, it's sort of done very quickly. Suffocation's not the purpose, and maybe that meter reader could be an issue.
If you can't prove a point, don't try to argue it, right?
I think that the evidence is there, and for all the reasons
there's no evidence of suffocation, none whatsoever.
The duct tape was present. It is a rational conclusion that suffocation is
unless you have a
the cause
medical
of death.
examiner who can say, I examined the body, the cause of death is suffocation. You don't have it.
I disagree. In cases built on evidence that is circumstantial, you have to rule out any other rational conclusions to explain it. And it's not rational to say that Mr. Kronk somehow was involved and tampered with the body.
Yeah, Mercedes, that is a problem because they did put on the witness stand a forensic anthropologist who said, look, when that body was placed there, because the vertebrae is still intact,
right.
That body was not tampered with, essentially. It had been there in one piece all along. Doesn't that render this outrageous claim of the defense of Roy Kronk tampering, kind of preposterous?
But he seems so creepy. He's got a lot of that creep factor, and Greg, you're a trial attorney. You know the creep factor is going to get into this trial.
That's all I ever represented were creeps.
Wait a minute, you worked at my firm. That's not true.
That's true.
But no, certainly the issue is going to be, you've got the creep factor. You also have a whole other issue, is that a lot of jurors don't want to believe that a mother is capable of killing their own children.
But you know
what? They just can't make that
Kirsten,
leap. And if there's a way to
she cried on cue yesterday as, they were talking about the intimate details of the bones, the vertebrae, and all that horrid stuff. There she is. I mean, jurors look at defendants when they do that. And so is that a mother who's crying because of what she did or crying because of the loss of her daughter at somebody else's hands?
You never know. I mean, you've been through situations like this where you're sitting in a trial. People react in stressful situations in a lot of different ways, and frankly, the jury interprets them in a lot of different ways. Sometimes they're going to have sympathy for somebody. It's a normal reaction if you did not do it to cry, but you can also interpret it as crying on cue.
If she was stone-faced through those pictures, I mean, there were jurors
then
there
she'd be dead man guilty.
Absolutely.
Exactly.
So whatever they had to do to get her to cry on cue was a brilliant part.
84 searches for chloroform and how to make it on the Anthony computer, which the defendant had access to. And evidence of chloroform was in the car. It could have been used to kill little Kaylee Anthony.
But the good thing for the defense is that there isn't any conclusive evidence to show that. There isn't any medical evidence to show that the chloroform was used. There isn't that medical evidence, and I think that's what they're going to hang their hat on.
What in the world is the chloroform doing in the car to begin with?
But there wouldn't be. I mean, there wouldn't necessarily be after this period of time when the body's found. And it was found in the back of the car, which is an important point.
But also, she used to, at least the theory is that she would go out and she would do this to Kaylee without killing her. This is how she partied.
Right.
She didn't have money for babysitting, so she'd knock her daughter out.
That might have been a better defense. It was accidental overdose of chloroform. I didn't mean to. That's manslaughter, not murder, because it's not premeditated.
And you don't have the death penalty. I mean, this is a real serious stuff.
All right, Kirsten Wilson, Mercedes Coleman, thank you both.
Thank
Thanks,
you.
Rick.